Counsel for the accused made an application before this court that I recuse myself from handling miscellaneous application number 1 of 2025. Before court can pronounce itself on the application for recusal, there is need to determine whether this court has jurisdiction to entertain any application arising from the criminal case where the accused has been committed to High Court. Jurisdiction is a creature of statute. A decision by a court without jurisdiction is a nullity. Once the court finds that it has no jurisdiction to decide a case, it cannot take any further step in the case. The accused persons in criminal case number 8 of 2025 were committed to High Court on 29th May. This court, having committed the accused persons to High Court, does not have jurisdiction to make any decision or order after the committal proceedings. This court can thus not make any decision on the application for recusal because it has no jurisdiction to do so. The committal proceedings in criminal case number 8 having been concluded on 28th May. Accordingly, the accused is further remanded awaiting trial at High Court.
They have just been wasting our time. Obviously, it's no brainer, and it's obvious that once one has been committed to High Court for trial, you cannot reopen the case for investigation. It's no brainer. Even an ordinary person, a lay person would know this, that the jurisdiction of this honorable court is exhausted at a time when committal proceedings are conducted. In other words, we have a doctrine of functus officio. Once the lower court has exhausted its powers, its jurisdiction, its mandate, it becomes functus officio. In other words, its hands are tied. You have no choice but to terminate the proceedings. So that is the thing. This magistrate had no choice but to terminate all the proceedings relating to Dr. Besigye's case after conducting the committal proceedings on the 29th of May. And this has been actually waste of time. But on the side of the case, in regards to the merits of the matter, the substantive case before the High Court right now, it's a huge blow to the state, in that they wanted this evidence to support their charges. And it's the reason they put in this application, so that court could issue an order to allow them access the data on Dr. Besigye and Obed Lutare's phones, which court has now rejected because they have no jurisdiction. Obviously, as we explained, they had a dilemma. They were in a catch-22 situation. They were placed between a rock and a hard surface. They had 6 months within which to conduct the investigations, which lapsed on the 20th of May. But at that time, by that time rather, they had not exhausted all the investigations. And all they had to do is to admit Dr. Besigye on mandatory bail in accordance with the provisions of Article 23 of the Constitution. Yet they never wanted Dr. Besigye released. So they had to keep him on remand under all circumstances. But their time had run out. They had to close the case at that time. But they still had a pending application to access data, which they had to pursue. And there was no way they could still keep Dr. Besigye on remand after the expiry of the mandatory remand period of 180 days. So that's the catch-22 situation they had to deal with. So they wanted two things. One, to have Dr. Besigye on remand, but at the same time continue investigations even after the mandatory period of remand. They couldn't achieve both. So they had to go with one of the two. Either you have Dr. Besigye released on mandatory remand and continue with investigations until such a time when you are done and ready to proceed with the hearing, or you have Dr. Besigye committed to High Court for trial, and you forget all about the evidence which you wanted to substantiate your case. So that's where they are. So now where we stand today, they cannot have this critical evidence that they wanted to support their case. Because now the magistrate has, and rightly so, decided that she has no jurisdiction because she is functus official, she exercised that jurisdiction, and therefore they cannot proceed with the application to access Dr. Besigye's information. And that has far-reaching implications on the merits of the matter because they badly needed this evidence to support the charges before the High Court now. So that's the call we are making now that their case is hollow. They should have it withdrawn. It should be withdrawn because without this critical evidence, it's an exercise in futility for them to proceed with the prosecution. It's no brainer again to say that they have no case against Dr. Besigye without this kind of evidence, which they badly needed. And they cannot have it. It's a fait accompli now, it's gone, totally gone. Because the High Court cannot open even the slightest window of ventilation to allow them smuggle in this evidence. It's not possible. Kaput. So the case is completely kaput. The reason they should release Dr. Besigye. That said, for us, we are proceeding with the application for mandatory bail, which we filed upon the expiry of 180 days on remand. It's now pending before Justice Baguma. Only that we need to deal with the issue of management of the two files. The substantive case is before the ICD. Yet the application for bail is in the criminal division. So we are going to sort that out administratively and have this matter fixed for hearing so that we can have Dr. Besigye and Obedi Ritale released. Tutandike na Luganda. Kino babadde batumalira bumalizi budde. Era ndowooza omulamuzi yalibadde yakisalawo nakululirwe twasembayo okujja wano. Kubanga kirabwa n'ayonka n'atali puliida nti komito bw'emala okukolebwa fayiro n'ebuweerezebwa mu High Court ne bagamba nti obujulizi bwonna state emaze obbunoonya buweddeyo n'olw'ensonga eyo musango ogutandika okuwulirwa ate eno waba tewakyali business. In fact olwali twabadde tulina ne kitunona wano olunaku kooti nga 29 lwe yagamba nti buli kimu ekikwatagana n'investigation oba okunoonyereza kiwedde fayiro eweerezeddwa mu High Court hearing egenda lwe twali tukoma okujja wano bali mu kutuzunza Dr. Besigye bamuleeta wano Obedi Ritale naffe batutawaanya kati guno mulundi gwakubiri nga tujja wano oluvannyuma lwa komito kyakutuzunziriza babadde batuzunziriza bwereere. So ekyo kibadde obvious, kibadde kirabwa n'ayonka era twakibagamba nti tekibangawo mu byafaayo bya Uganda mu judiciary mu justice system yaffe nti omuntu amala okomitingibwa mu High Court ate ne tusigala nga tukyajja magistrate court. So ku side yaffe kituyisize bubi okuba nti tutawanyiziddwa okubanga batuleeta eno. Naye mu ngeri endala nti kirina implications nyingi nnyo ku side ya state. Era eno blo nene nnyo eri state eno kubanga ebadde mu catch 22 situation. Ennaku enkaaga ebadde mu catch 22 situation nti ennaku 18 zolina okukumira omuntu ku remand mu capital offences zaali zaggwako naye nga zaggwako ng'ate bakyalina obujulizi bwe baagala kakati nga balina okuta Dr. Besigye ku mandatory bail bo kye baali balwanyisa okukola komite ey'amangu nga tebannamalayo obujulizi kwe kuba nti baali bayagala Dr. aleme kufuna bail n'Obedi Ritale baleme kufuna bail mandatory bail ejja oluvannyuma lw'emyezi 6 kakati ne bapapirira ne bagaaka bakole komito naye ng'ate tebannamala kumaliriza bujulizi baagala okusumulula amasimu bafune obujulizi ne baagala to eat their cake and have it nti bafune komito Dr. Besigye bamutwale mu High Court okuwulirizibwa omusango gutandika okuwulirizibwa but at the same time basigale era nga bakyanoonyereza ekitaliyo mu mateeka kakati kitegeeza ki baafuna komito yaliwo nga 29 omwezi oguwedde meaning nti Dr. Besigye kati na Obedi Ritale balinda hearing naye kye batagenda kufuna bwe bujulizi bwe badde baagala obw'oku opening up amasimu kubanga kooti yokka yeyina okulagira ate ina kuba kooti ene ya wansi eri eya waggulu yeewuliriza musango nga guwedde obujulizi buwedde okunoonyerezebwa So high court tewaayo obudde bwagamba nti ate muddeeyo munoonyereze. Kakati kitegeeza nti omusango oguli mu high court ogugenda gwe baweerezaayo for trial tegulina bujulizi, kubanga obujulizi bwe badde baagala buli ku masimu gano ge boogerako. Kati ate tebabakkiriza gaggula obujulizi bwe badde baagala tebabufunye. N'olw'ensonga eri guli omusango nagwo si dead completely mufu, kuba tegulina bujulizi. Fayiro bagiweerezaayo nga kiwowongole, temuliimu busomyo, temuliimu bujulizi bwe baagala, tebuliimu. Fayiro yagenda. Kati ate kooti ebagambye ffe engeri gye twaweereza fayiro mu high court tetukyalina bujulizi buyinza bubakkiriza genda maaso nakunoonyereza. So tubagamba n'ogwo omusango bagugjeyo bate Dr. Kizza Besigye kuba tegukyalina makulu. Obujulizi obukulu bwe badde baagala tebuliimu. So nagwo era gwakumala budde. So kyekitegeeza ffe kyetuddako mandatory bail application yaffe ekyaliyo. Yadde Dr. Besigye n'Obedi Lutale baba committinga mu high court, tekitegeeza nti kibajjako right yaabwe okufuna gye bayita mandatory bail omuntu ng'awezezza emyezi 6 ng'ali ku remand nga fayiro tenaweerezebwa mu high court. So n'olw'ensonga eyo application yaffe twagala ewulirwe. Bagiwadde Justice Baguma yagenda ogiwuliriza, naye ebyo tugenda bimanaginga kuba ate eno fayiro kati eri mu ICD, eri mu International Crimes Division, fayiro eya case, substantive case, naye eya bail ate eri mu Criminal Division owa Justice Baguma. Katugenda kulaba ebyo bwe tubihandolinga. So tugenda tannaba kutuwa lunaku, naye twagala ebyo tulabe we tubimaliriza ebya mandatory bail, kubanga tekijjawo right ya Dr. Besigye ne Obedi Lutale okufuna bail oluvannyuma lw'okubeera nga baamala ennaku ezisukka mu 6 mu 18 ku remand.